So this is an actual, well, it's a, it's a, I suppose it's a PDF, so it's several layers removed from, an actual document, but it's a representation of the recent decision made by the Supreme Court, Dobbs, State Health Officer of the Mississippi Department of Health et al. Versus Jackson Women's Health Organization et al. So Dobbs versus Jackson, and what I there's a lot here, and it's very difficult to it's psychologically difficult and emotionally difficult to read Alito's decision, because almost every sentence drips with patriarchy and sort of a misrepresentation of history and its underlying premises and unexamined and its unexamined underpinnings. And some of those underpinnings include what I would call the misuses of history. So that there are often arguments about what constitutes constitutional liberty, and the idea that Alito presents is that anyway, he in various moments he cites precedents in arguing constitutionality that refer to this long history of states' relationship to certain rights, and then beyond that to the Constitution itself, and then beyond that to English common law. And he cites this Anglo-American heritage. So already, within the assumption of what is in fact a liberty and that belongs to constitutionality is the history of a particular misrepresentation of Anglo culture and the way that it actually operated, and what was at the surface and what wasn't. And of course, what Alito misrecognizes, at the very outset, is that issues of women's health and the concerns of women's bodies were historically have a long history of being women's concerns, and not part of the patriarchal textual record, and in fact are informed more by oral histories and practices than they are by common law. And what exists as textuality in common law, often, just as in ancient Semitic culture, isn't often part of the text. So you don't really find in Leviticus a lot of stuff concerning abortion, and the misrepresentation of history is twofold. So the first misrepresentation of history is that we can find precursors and historical justification for our understanding of what personhood means and what women's rights might mean in common law, and where they're largely unavailable, because as I said, the textualizing of that law largely has to do with propertied relationships between men, and not what the common practices of women's health and body rights, insofar as ideas of both hygiene and care are concerned. And then the second misrepresentation is of history, in Alito's, that interests me in this decision, is what's unstated, and of course what's unstated is that the idea of abortion, being, and let's not use the word crime because it was not intention, not initially framed that way, but this Roman Catholic idea that that abortion somehow is a sin is not a part of a long history and tradition that belongs to the culture that it claims to grow out of. And so it's interesting that, and of course, the two Jewish representatives of the Supreme Court, seem to be aware of this, and were two of the three, that had dissenting opinions. But what emerges, right, and is justified, in this history of Catholicism as an understanding of abortion as falling under this sin of murdering the person, was never there in the historical understanding of certain ancient and tribal traditions, and so of course Kagan and Breyer, seem to be aware that that of this long history of this long women's history, perhaps silent in the at the textual surface of the cultural document, but certainly present if one reads between the lines. Aware of this history that this masked, right, understanding of the history of common law, and I say masked because what it's really hiding is the Roman Catholic impetus that is in fact behind the patriarchal gesture of ownership and control of women's rights to choose what to do with their own bodies. And so to mask that patriarchy, one has to misrepresent the history, and I find it interesting that that history is misrepresented in this double move. So a pretense that the ideological motivation, doesn't belong to the apparatus of Roman Catholicism and Roman Catholic patriarchy. That's one of the moves, and then this other move, which cites, the necessity for a long precedent in this particular, Anglo-centric history that belongs to common law, and in some cases even a broader scope of recognizing this Euro history and belonging to the Magna Carta. Okay, so that's what interests me about this, and effectively, I mean, we could say that not only is this this document which pretends to be about the rights of states' citizens to make their own decisions, is effectively a mask that in which Alito veils the fact that the decision is largely made, based on his ideological interpretation of what constitutes a person and what constitutes a person who belongs to the sphere of possessing rights and liberty, and what he's hiding, in this double deployment of the misuses of history, is that for him, women don't have rights over the uses of and care and protection of their own bodies because we have a long history of not stating such a fact, and because indeed the United States was founded as a patriarchy, and women were in fact property in many ways, and a child was the property of the father and not the mother. And if we want to play this game out effectively, the Supreme Court, has the right to deny any of those progressive developments in history that have occurred, since the founding of the United States, and hence, we really have no protection of any right that wasn't granted to any of us, prior to 1776. So that's frightening in terms of the future history of the Supreme Court. But what this suggests is that for liberty and life, and for women's health to progress any further, we need to demand and insist that the Equal Rights Amendment, is finally becomes finally part of the Constitution, and is incorporated into the rights that we adhere to in the United States. So it's certainly long overdue, as it was introduced, to Congress twice and never ratified. But I suppose, in light of this document and its double misuse and abuse of history, and the forms that takes, and not only that, but a call to particularly feminist scholars interested in this, but and there's certainly a lot of material available, but get it to the Supreme Court, a history of this particular branch of patriarchy that belongs to Roman Catholicism, and its deployment of arguments that are anachronistic and that never belonged to the history of either European culture, nor to the religion, which it claims to be founded upon, and like I said, Kagan and Breyer, seem to be aware of this, probably because obviously, the unsaid, right, part of the allegiance of one's ideology of faith and personhood comes into play in these decisions and arguments as well. And having an understanding of this history, and the we could say common practices history involved in women's health, as they are not contaminated by the papal bulls and papal encyclicals and the misrepresenting of women's health over time, by other institutions as well, or witch hunters in the United States are who seem to provide some of the underpinning for Alito's argument. Are aware that however untextualized these histories continue to be, these practices, indeed do have the practices of women's health and the rights of women to determine the course of their pregnancies and their relationships to their own bodies and the decisions they make about the course of their reproductive lives are in fact, if not stated in the texts of common law, historical practices, and these practices and praxes should enter into the scope of a definition of what liberty is. If the basis for defining liberty is in fact historical precedent, and so what becomes interesting in these abuses and misuses of history is that they're made in secretly, or hiddenly, or without awareness, perhaps, but they're made in these textual terms, right? So that the textuality of history is in fact what's privileged when, and I'm referring to, the textuality of history that relates, not only, to performative textuality, but descriptive textualities as well. So it becomes more real for Alito if it was written down, either as a law or in a text. And for example, there's no reason to cite Isaiah Berlin and his 200 different definitions of liberty, other than that it has this patriarchal authority in relationship both to this figure and its definition as a widely reproduced textuality. Now whether or not it has any merit otherwise is never questioned or examined, right? So one of the things that I find interesting about how history is used here is that the authors were always men, right? So they're the ones that created the texts. So that if we privileged text and not historical practices or praxes, then we're always privileging patriarchy in the definition of what not only liberty means, but what personhood means. And so the argument in its exclusions and inclusions is has a depth that needs to be unmasked, and that demands our intense scrutiny on all of these different levels. And I suppose that that is what this brief examination of what I see going on here requires before we can get out of this hodgepodge of lunacy that really that his representations present, and that have almost nothing to do with the real issues behind this decision, which are to take power away from women and to absolve women of the rights that personhood in fact entail. And so once again I see it as a kind of Spanish Inquisition in a certain sense, right? In which individuals were also burned as they were here in the early period of the United States, whose Commonwealth law was often in fact overlooked rather than supported by the burnings of women accused of witchcraft, which is precisely what I see going on in this misuse and abuse of historical understanding. So again, this is a call for the unveiling and unmasking of the history of Roman Catholic patriarchal violence in its production of textualities that misrepresent, right, the ancient history and praxes that may or may not become part of these sacred texts, but not being in examples, such as Leviticus absence, means something, as I said before. Kagan and Breyer seem to be aware, and the Roman Catholics on the Supreme Court, seem to be oblivious of. Because why? Because of the fact that after 1,500 years of propaganda, right, and distortions of what ancient understanding was, that they've come to accept the positions of personhood, that were that became part of the ideological apparatus of interpreting what Christianity meant, in relationship to Judaism, in ways that it was never actually meant by by the historical figure of Christ. And so, the real underpinnings here are the varieties in which history is misrepresented, and to get to those, you have to look at the ideologies that inform subjectivities like Alito's and others, and Thomas's and the other Roman Catholics that are unstated, because they can't be, because they don't have any legal authority or precedent here, but they're there, and so you have to unmask them first of all, and do that work, and then you have to unmask the misrepresentations of what Alito presents as his legal understanding of history, which is also largely erroneous and misinformed. And then you it's a lot of work, isn't it? And then you have to uncover this history that doesn't belong to textuality, and explain why it doesn't belong to textuality. And it's it's not that different from the process that I went through when I looked at the discussion of the life of Equiano, right? And this racist attack on on one of the first writers, the first textualizers of a narrative of slavery in the United States and England, and the way that the production of this narrative was interrogated and held against the scrutiny of documents, right? And these documents were given the authority, and if there was a discrepancy between Equiano's account and say a ledger that included him or failed to include him, or included him with a different name, in either a birth record or a ship's roster. This was the tool that was utilized to describe Equiano's account as less than historically accurate. In other words, as fiction. And yet, what wasn't examined and what wasn't interrogated were all the assumptions that belonged to that moment of history. Would Equiano have been allowed to, right? Would he have been allowed to register in such a way or not at this period? Would his name necessarily have been included in this text? Because of the relationship that he, as an example of not an individual possessing what we define as liberty, but as an example of human property. Was the measurement, in fact, of the way that he was inscribed within these textual documents, and the same can be said of women's history in the articulation of these textual documents, which will necessarily, right, leave women out, whether there are practices and praxes that belong to traditions of accepted rights and a kind of normalcy or normativity of cultural values that in fact are more accurate representatives of a common history and a common ethical past. So at the very outset of the text, where Liho maintains, let me see if I can find it. At the very outset here, where Alito maintains that abortion presents a profound moral issue on which Americans hold sharply convicting views. If we, in fact, want to make that claim and argue that it is a moral issue, then the cultural history included in the formation, of a discourse that involves morality and ethics has to be more encompassing than what is represented at the surface of these textual misrepresentations of history. And you need to do the actual social history and the actual work that involves an understanding of women's health issues over time, and who was in fact responsible for addressing these issues, and who in fact was responsible for their maintenance and care. And without that, you have nothing more than an ideological representation of patriarchal values that's equivalent to what I would call a papal bull or an encyclica of misinformation.